Don't forget to like, subscribe and share the videos.
Welcome to Ganesh IAS Academy. I'm Mr.Bhuvanesh. I cleared Indian Forest Service exam 2023 with an all India rank of 98, and this is just a set of current affairs sessions which is done to which is done keeping Prelims 24 in mind. So since we have just another 2 weeks, hardly like 10 days or like 13 days before prelims exam, we'll not be focusing on like creating content, but because by this time like any serious aspirant would have already finished reading content, and they would have been focusing on like revising and solving previous year question papers. So but the focus of this set of sessions will be to predict a few, not exhaustively, but as many current affairs as possible, right? Predict as many current affairs as possible, and just try to give the aspects that you need to cover so that the chances of question being asked is high. So that is the purpose of this session. So we'll be starting off with polity and governance, and after that we'll go on with environment, geography. There will be a session on economy, then there'll be one on science and technology, and finally we'll just wind it up with history and art and culture. So this is how we've planned this set of sessions. We'll be like doing another 5 or 6 sessions in total, so that this set of sessions will like help you to reassess your preparation, and if at all you have any voids in your preparation, you can like fill those voids. So that is the focus of this like the another 5 or 6 sessions that we are going to see. So content is like secondary here, but anyways, like I'll touch upon a few of the contents which is not like very conventional, or which you might not find in a lot of like textbooks. So those kind of contents I'll try to like slightly touch upon. But apart from that, majority of the content I expect like we expect you to like know it already, or if at all the references that I give, certain things I might explain and certain things I might not explain. But the things which I'm not explaining, which can be like easily accessed through a lot of sources, your books or your internet or like any government reports or whatsoever. So content is not the main focus here. So the main focus is on the areas that you need to work on. So that is the main focus. So we'll just start with polity and governance. And yeah, if at all possible, I just like try to connect the previous questions that have been asked by UPSC in prelims exam with the topics as well. Okay, so we'll just step into this polity and governance. So the first topic is parliamentary privileges. So the reason why there's quite a good amount of chance that this you can expect a question from here is because of recently there was a few months back or a few weeks back, Mahua Maitra MP from West Bengal, she was expelled from Lok Sabha. So considering that, you can expect a question on parliamentary privileges. So the first thing which you need to focus is on the sources of privileges. In India, we do not have a well codified set of parliamentary privileges, but we have it from different sources. So the first was being constitutional provisions, and you have a few legal provisions, and you have it from parliamentary conventions, which is like followed across the world, and also conventions which are a part of the Indian parliamentary culture. And then we have privileges which are interpreted through various judicial verdicts. And then one crucial aspect is from the rules of procedures of both like the Lok Sabha as well as the Rajya Sabha. So those are the lists of privileges, sources of privileges. The key point to note here is we will not have a very exhaustive and a single codified set of privileges. So that is a key point to note here. And what are the sources of privileges that you need to make a note? And then these are like a few constitutional articles which like I've mentioned here. So just go through. So this to just give you one briefing is 105 clause 1. It deals with freedom of speech and expression on the floor of the house. So similarly, you have like 105 plus 2, 122, 1, 122, 2, and 361A. So you just have just skim through what each of these articles, what are the privileges given by each of these articles, and you just make a note of it. You need not memorize, but you just understand what are the privileges like arising from these articles. And then you'll have individual and collective privileges. What are individual and collective privileges? Individual privileges are privileges which are enjoyed by the MPs alone, whereas collective privileges is the privileges which they enjoy together as by virtue of being an MP. So some of the individual privileges are they have freedom of speech and expression on the floor of the house. They cannot be prosecuted in the court of law for anything that is spoken on the court of the on the floor of the house, or for the vote that they, or for the vote on the bills that they are doing. And then they cannot be like arrested before and after the 40 days of uh, parliamentary sessions. So that is the individual privileges. And collective privileges is they have uh, they have right to conduct their own sessions, and they have right to have secret sittings, and they may allow or they may not allow strangers during the proceedings of the house. So you have a list of like individual and collective privileges. So I'll just go through that. And then next thing is this role of Lok Sabha and Rajya Sabha presiding officers in suspension of the members. I think this we'll see it later also, but since it is regarding with expulsion, so we have to like see that also. One difference in the presiding officers of Lok Sabha and Rajya Sabha in suspension of members is in Lok Sabha, your speaker can suspend a member, and also the house as a whole can adopt a resolution and suspend a member. Whereas in case of Rajya Sabha, the presiding officer does not have the power to expel a member. It can be done only by the house. So that's the difference between suspension of members in Lok Sabha as well as in Rajya Sabha. So apart from this, I think we have to like read about ethics committee. What is ethics committee? Like how does an ethics committee operate in Lok Sabha and Rajya Sabha? How are the members chosen? Who heads that committee? What are the roles of those committee? So I think all those things must also be covered. And then overall parliamentary committees as a whole. Just give a brief and a quick rush through about the different parliamentary committees, ad hoc committees, standing committees, and then you have public accounts estimates committee, committee on PSUs. So just give a quick skim through regarding all those committees. I think if you do that, like reasonably, you can expect a question on in and around parliamentary privileges. Like moving to the next one. Next one is like regarding the concept of bail. I think very recently, in like since 21, 22, 23, UPSC is like started asking questions from governance aspect as well, say with regards to jail, bail, or connecting history with like polity. So UPSC has started asking questions like that. So going by the recent like 2 or 3 years trend, we can expect a question on bail, because like one good reason is recently we had the Delhi chief minister being arrested, and the question of his bail petition was pending before the Supreme Court for a longer period of time. and after so many speculations, he was granted an interim bail. So that has started a discussion around the concept of bails. So I think that is there, and also role of enforcement directorate. Like very recently, in the past 2 years, we have seen enforcement directorate arresting a lot of like politicians, and there is often like accusation regarding that role and regarding their role, and also bail has become like prominent there also. So you can expect a question on that. So first, we need to be aware of certain terms: bailable and non-bailable offences. Like just from their names, you can like see there are certain offences for which you can be granted bail, and there are certain offences for which you cannot be granted bail. And this bailable and non-bailable is defined under CRPC. It's not defined under IPC, so this is very important. So criminal procedure code, so it's defined there. So next thing is, next other terms are like statutory or default bail. Statutory bail is when when you are an accused, and the police or the investigation side is not able to like prove that you are guilty of your offense within a reasonable period of time. So under such circumstances, you are eligible to get a statutory bail. So that bail is a matter of right, actually. Bail. And anticipatory bail is like even before you're arrested, if you sense that you are going to be arrested, then you will be granted an anticipatory bail, and everything comes under CRPC. So that must be like noted. And then next thing is, you need to know the difference between a charge sheet and an FIR. Charge sheet is like usually filed just before the trial, after every investigation is done, and all witnesses have given their uh, all witnesses have given their whatever aspect they know. So a charge sheet is usually filed just before the trial, whereas an FIR is the first information that is written by the presiding officer, or usually an SI or an inspector, just after the crime is committed. And like usually an FIR serves as a primary document for building a charge sheet. But charge sheet, the details that are filled in charge sheet can be different from the FIR also, but it's usually the charge sheet is built over and above the information that is there in the FIR. So I think that's the difference between these two. And next thing is ECIR. See, like ECIR, there is no much there's no much like connection between the concept of bail and like ECIR. But the thing is, there was like I think some 2 or 3 years before, there was a Supreme Court verdict telling that comparing an ECIR charge sheet and an FIR. So recently, Supreme Court had said that ECIR is not a public document and it need not be disclosed, just like an FIR or a charge sheet. So, and the ECIR is like basically enforcement case information report. So it is basically a kind of FIR that is filed by the enforcement directorate in money laundering cases. So I think you should know the difference between ECIR, FIR, and a charge sheet. Okay, the next thing is the favorite like department of the opposition parties in recent times. So that is like the enforcement directorate. So I think there's no reason for me to like tell why enforcement directorate is in news. It's like it's quite very popular now. Enforcement is very popular now. But setting politics and other criticisms aside, like analyzing it objectively. So first we need to know about the nodal ministry. Comes under Department of Revenue, Ministry of Finance. And it is given the legal mandate to enforce FEMA, Foreign Exchange Management Act, Prevention of Money Laundering Act, and Fugitive Economic Offenders Act. So your enforcement directorate is a nodal ministry for all these three acts. So like that is very important point to note. And all the offences that comes under your enforcement directorate are cognizable and non-bailable. Cognizable means you can arrest a person without a warrant. So that is cognizable. Non-cognizable means you cannot arrest a person without a warrant. So all the uh, offences which come under which are dealt by enforcement directorate are cognizable and non-bailable. So you will not get bail also. And you should be knowing about the recent amendments to Prevention of Money Laundering Act and terms like predicate offence that was done and something related to ECIR which we had like discussed in the previous slide. I think you should give a glimpse about all that. And for mains perspective, like you can like see how Prevention of Money Laundering Act is or the recent amendments is it like hampering the fair trial that is given to the accused or not. So that is something which we'll discuss for mains, but going for prelims, I think all these are enough. Okay, Mixed Selection Commission. This is like very popular institution now because like we are in the election, general election year, and there is like quite every day, at least once in one page or like once in two pages, like you'll hear this term election commission. So there is like quite a good amount of reason to believe that you'll get a question from election commission. But to be very precise, recently Parliament had passed this bill, election chief election commissioner and other election commissioners appointment, conditions of service and terms of office bill 2023. This was passed based on Supreme Court direction in Anup Baranwal case. So this the verdict of this Anup Baranwal case is like very important because for the first time Supreme Court had said that the election commissioner must be appointed by the president after suggestion from a selection committee consisting of prime minister, leader of opposition in Lok Sabha, and chief justice of India. This was the verdict that was given by Anup Baranwal case. But this bill, this had actually changed this to prime minister, leader of opposition, plus one union minister. So that is making the selection committee more tilted in favor of the executive. The chief justice of India has been replaced by the union minister. I think this difference must be known. And then next thing is you have to like read the Article 324 in entire. Like the Article 324 gives the conduct superintendence of election. It vests the power of conduct and superintendence of elections to the election commission. And in fact, that article gives the election commission enormous power, and it has led to a lot of inventions by the election commission, be it the voter ID or bringing in the model code of conduct. Everything like flows from Article 324. So all those must be like, you must have a fair idea about like what is given in 324. Next thing is there is you need to compare Article 324 and the new act. For instance, I'll just give one or two differences between Article 324 and the Chief Election Commissioners Act, which is like passed now. The Constitution of India, it does not give any qualifications for the Chief Election Commissioner and the election commissioners. But the Act, it has given certain qualifications. So you have to like know what those qualifications are. I think the election commissioner, he or she must be in the rank of Secretary to Government of India, must have retired, and also constitution is like silent upon whether they can be reappointed or not. But this act like tells that your election commissioner and your chief election commissioner cannot be reappointed at all. And if at all your election commissioner is if at all your election commissioner is like being appointed as the chief election commissioner subsequently, the aggregate term for him or her to serve as election commissioner and the chief election commissioner together is like 6 years. And the 6 years 65 age of age, that is also given under this, it's not given in the constitution. So there are other differences as well. So you have to like just draw a table between like what, first start with this act, because this act is talking about a lot of aspect which 324 is like silent on. So I think those must be seen. So yeah, one thing is like qualifications. The new act, it tells about a qualification, and the new act also it gives info on search committee. Search committee will be headed by Union Law Minister and two other government officials who are not below the rank of Secretary to Government of India, and they'll be suggesting some 5 names or something for the selection committee. Your selection committee will have Prime Minister, Leader of Opposition, and one Union Minister, and the selection committee can consider people who are not even recommended by the search committee. So the names that are suggested by search committee can be altered by the selection committee. And then terms of office, 6 years or 65 years of age, that is also mentioned in the new act. And then reappointment, your chief election commissioner is not subjected to any reappointment. Salaries and allowances are similar to the of a judge of the Supreme Court. Resignation, the chief election commissioner can resign by like submitting his resignation to the president, and they can be removed as a manner in same as that of a judge of a Supreme Court. And then the constitutional protection to chief election commissioner and election commissioners. The election commissioner cannot be removed except on the recommendation of the chief election commissioners. So I think this aspect is not really modified by the act, because the constitution itself has already given that protection to election commissioner, but the election commissioners cannot be impeached. Whereas you're impeached as in the way your judges of the Supreme Court are like removed. So it's like a highly probable area for you to expect a question on election commission and the mode of appointment of election commissioners and the new act. So this is something which you need to focus on. Next is the Office of CAG Comptroller and Auditor General. So why is it news is there's recently a PIL in the Supreme Court for and seeking an independent process to appoint the Office of CAG. This is something similar to, this is actually an outcome of the verdict in Anu Baranwal case, where the demand is for appointing election commissioner based on the recommendations of Prime Minister, Chief Justice of India, and the Leader of Opposition. So this is like this demand is something similar to that. So I think being in constitutional office, I think you can expect a question. So you just read through what these like 4 articles talk about: Article 148, 152, 151, and then your CAG is the one who certifies net proceeds of taxes, and his certification is the final, and it cannot be like challenged anywhere. And usually you have this term is a friend, guide, and philosopher. Usually, like you can use this term for answer writing in mains, but you can like for prelims you can just know. And then you have this CAG duties, powers, and conditions of service act, which is like quite exhaustive, and it like talks about the roles, responsibilities, and the duties that the CAG must perform. I think you just skim through like all those. I think that will be fine. And then this 1976 amendment is quite important because it had separated the auditing and accounting like separately from the office of CAG. Previously, your accounting and auditing was done by CAG, but now you have Controller General of Accounts who takes care of accounting, and then you have CAG who takes care of auditing. So that's the like difference. And if you like know this much, it's like fine for prelims. When it comes to mains, we'll discuss a few more. Okay, this is something like we discussed initially, but you had like over 140 MPs were suspended during the December session of the parliament, and after suspension of 140 MPs, you had like very important bills like the Indian Penal Code Amendment, CRPC Amendment, and the Evidences Act Amendment with some different names. Those were passed when you had a lot of like MP suspended, and so this is like very important. And then you have to like, as I said, you have to like know about the difference in the powers of the presiding officers of both Lok Sabha as well as Rajya Sabha and their role in suspension. As I said earlier, your Lok Sabha speaker can suspend a member, or the House can adopt a resolution to suspend a member. But whereas in Rajya Sabha, your House alone decides suspension. Your presiding officer of the Rajya Sabha, that is the vice president or the Rajya Sabha chairman, has no say in suspension of members of Rajya Sabha. So that is the difference which you have to like know. And then revoking the suspension is with the House in both cases. So that's the difference that you need to know. Moving forward, next is yeah, access to justice. See why this topic, like I've chosen this topic is, as I said, the UPSC has started shifting, slowly shifting from like the core constitutional aspects to the operational aspects of constitution. So one area where they focus a lot is this uh, alternate dispute resolution mechanisms and NALSA. I think in 2020 or 21, if I'm not wrong, it's in 2020, I guess, where there was a question on NALSA, and there was a question on who are the eligible beneficiaries. There were like four options, and two were like eligible, and the rest two were not. So we had a question something similar to that. So that's the reason why I have picked this. And also, there's one more reason for me to pick this topic is you have Article 14, 21, and 39A, everything put together that has led to this innovation of free legal aid. You have that concept because you have right to equality, and your justice might not be accessible to a lot of people who are from the marginalized background. But if suppose your access to justice itself is different for the wealthier section, the powerful sections of the people, and the marginal sections, then your Article 14 cannot come into place. So if you want to have right to equality, you need to have free legal aid, and if you want to have like right to life, right to a dignified life, I think your free and legal aid comes in. And then you have this NALSA, National Legal Services Act. So you just need to know about the purpose, when was this act formed, and who are all the eligible. You have a list of beneficiaries. So also, I think 2020 there was a question on this. So you might expect a question this year also. The list of beneficiaries that is needed, and then the state legal services authority and district legal services authority, and who is the patron in chief of NALSA. Your Supreme Court Chief Justice is the patron in chief of a National Legal Services Authority Act. So you just have some idea about like all those. Next thing is like pro tem speaker in the flow test. Why I picked this is something which is, see, we are in an election year, so definitely before like our elections are due. I mean, election results are due. in a few days, and definitely in the coming days we will have our 18th Lok Sabha convened, and then definitely you'll have a pro tem speaker who administers oath to the other the newly elected MPs. So this might be a question which might not have like come up in current affairs, but has a great relevance to this particular election year. So that's the reason why I've picked this topic, being a pro tem speaker and the concept of floor test. And the concept of floor test why I've chosen is this is speculation that we might be like going in for a coalition government this time. So in that case, a floor test is going to become mandatory. So like somehow, some way or the other, directly or indirectly, it's going to become very important. So that's the reason I've like picked this. And then you need to know about the pro tem speaker. So this is like R. Pro tem speaker, you need to know about the roles and responsibilities, roles and powers. Like and the pro tem speaker is like appointed by the pro tem speaker is like appointed by the president or the governor, because there's a constitutional provision which tells that whenever the post of speaker or the deputy speaker, chairman or the deputy chairman lies vacant, it is upon it is the responsibility of the president and the governor to appoint any member as the speaker to like take care of the proceedings of the house. So under that constitutional provision, you have a pro tem speaker, but constitutional as such doesn't use the term pro tem speaker, but it's just an implied um, implied use from the constitutional provision. So that thing you need to know. And then role of the president, governor, and the speaker in all this. And usually when the new speaker, when the election for the speaker is like announced and the new speaker is elected, this pro tem speaker, the office of pro tem speaker, it cease to exist, and then there is an oath for the pro tem speaker, so that you need to know. And then the election to the post of speaker is determined by the president, and it is like conducted with the election commission. So sorry, not the election commission, it is like determined by the president, and the secretary general of the Lok Sabha or the state legislative assembly or the Rajya Sabha, they take care of this election. I think like that is like important. Yeah. Next thing is this advisory jurisdiction. Advisory jurisdiction of the Supreme Court. It comes under Article 143, and why I picked this is just after the electoral bond case, there was a letter from the Supreme Court Bar Association head to the president asking her to asking our honorable president to exercise this to get recommendation from the Supreme Court even before operationalization of the verdict. So that's the reason like I've picked this. So it's usually like Article 143, and your Article 143 is a special power of the president actually. It's not the power of the Supreme Court, it's actually the power of the president to consult the Supreme Court. So you have, I think, two clauses, clause 1, clause 2. The clause 1 deals with like suggestions for any law or rule which has a considerable amount of public interest in it, and your clause 2 deals with pre-independence treaties, conventions, all those. I think in this 143 clause 1, it is the discretion of the Supreme Court whether to render advice or not. But in Article 143.2, it has to give, the Supreme Court has to give its advice. So that is it. And for this purpose, a constitutional bench is convened, which is usually at least five. You will have at least five judges in the court, Supreme Court. That's it. So that's the constitutional bench. And the role of president and council of ministers. So here, seeking advisory jurisdiction is not the discretionary power of the president. Rather, it is exercised by the president on the aid and advice of council of ministers. So this is not his or her discretionary power. So that must be known. And then, yeah, discretion of the Supreme Court and President. This thing, like I've told, is not a discretionary power of the President. The President exercises this power using the based on the aid and advice of the Council of Ministers. And then it's a discretion of the Supreme Court to whether to render advice or not in Article 143 Clause 1, but it has to give advice on Article 143 Clause 2. And then here you need to like know about the other jurisdictions: original jurisdiction, direct jurisdiction, appellate, special leave. Special leave is like Article 136. The original jurisdiction is like settling disputes between states, or like between state and union, or between center and state on one side and the other states on the other side. So you have to like have some idea about what are the original jurisdiction, the jurisdiction, and appellate jurisdiction. And appellate, you have like both. You have criminal appellate and then you have civil appellate. So all those areas you need to have some idea. Okay, the next thing is like state legislative assembly. So this year, like I am expecting a question on this, either directly or indirectly, because Jammu and Kashmir and Ladakh, there was like demand among from the civil societies and the opposition to conduct elections, the state legislative assembly for Jammu, Kashmir and Ladakh, not Ladakh, maybe like Jammu, Kashmir. So, so basics, the basics of like state legislative assembly, I think it is there in any material, any polity material that is there in the market. It's available in Lakshmikant and it's available in Sir's Ganesh Sir's book also. I think you just need to skim through it. But the areas which you need to focus more on is the difference between similarities and differences between your state legislative assembly and your Lok Sabha. I think that is something that you need to like seriously focus. For instance, your Lok Sabha has the powers to amend constitution, but your state legislative assembly doesn't. So that's one difference. Then, what are the administrative wise? There are a lot of differences between like state legislative assembly and Lok Sabha. I think those areas you need to work on. And then the similarities with respect to passing bills, passing money bills, passing of budgets, budget discussions, parliamentary committees. I think you will have a lot of similarities between Lok Sabha and state legislative assembly in those areas. So you need to like read the state legislative assembly in comparison with Lok Sabha. I think that will do a good analysis, as well as you'll be able to cover a lot of content. So that must be known. And then you need to compare your state legislative assembly with your state legislative council. I think one difference is, if suppose there is a bill that is originating in your state legislative assembly and it is like passed by the assembly and it is like given to a state legislative council, even if the council is rejecting the bill and if it is like passed by the assembly again, with or without modifications, the bill is deemed to have been passed. So your state legislative council has a very little power in terms of blocking or like making the bill to keep the bill pending. So the power of the state legislative council to influence your bills is like limited. It's not like it cannot, but it's very limited. And then this is like very key. You have to compare your state legislative council with Rajya Sabha. So one thing is like your Rajya Sabha is a permanent house. The state legislative is also a permanent house, but it doesn't exist in every state. I think hardly like some 5 or 6 states have state legislative councils. So it's like optional. Your Rajya Sabha has like very special powers like creation of an all India service or its role in constitutional amendment bills or in passage of normal bills. In case if Rajya Sabha is not accepting a bill and it is rejecting a bill means the bill is not deemed to have been passed. So like even if the Lok Sabha passes the bill again with or without amendments, the Rajya Sabha can stall the bill, but a state legislative council cannot. I think in the first instance it can delay by 30 days, and in the second instance it can delay by 10 days. So maximum 40 days is what the legislative council has the power to delay a bill. So I think there are a lot of other differences between your state legislative council and Rajya Sabha. I think those differences you need to like have some idea about. So yeah, the next is disqualification of MPs. See, there's a lot of difference between expelling an MP, suspending an MP, and disqualifying an MP. I think those differences you need to know. So the reason why like I've picked this current affair is uh, Rahul Gandhi, MP from Wayanad of the Indian National Congress, he was disqualified for his 2 years conviction in a defamation case. And also you have discussion on this anti-defection for quite a long time. I think like that's the reason like we have picked this topic. So your constitutional provision, Article 102 Clause 1 and 191 Clause 1. The question of disqualification is decided by the president in case of your Lok Sabha, and it's decided by the governor in case of state legislative assemblies, and in either case the president and the governor acts on the recommendation of the chief election on the advice of the election commission, and the advice is binding on the president. So this thing you need to know. This is like very important. Article like 102 Clause 1 and 191 Clause 1. And next thing is like anti-defection, Schedule 10. And like anti-defection for like all the wrong reasons is in news at least for the last like 4 or 5 years. So any year they might ask. It could be like as simple as the grounds of defection, and it could be even the committees that have recommended regarding anti-defection, either the second ARC or Dinesh Goswami committee or Indrajit Gupta committee. So anything, any question can like, come from anti-defection. And the next thing is grounds of disqualification. So I think this grounds of disqualification is something which has been not been touched upon by just not been touched upon by UPSC, but you have quite a lot of chances to be touched upon. I think the first thing is Representation of People's Act 1951, and in that you have 8 clause 1, clause 2, and clause 3. So if you are convicted under Indian Penal Code, Protection of Civil Rights Act, UAPA, Prevention of Corruption Act, and POTA Act, you'll be disqualified under section 1. I mean section 8, subsection 1. For hoarding, profiteering, and adulteration and dowry prohibition, if you're convicted under any of these 4, you will be disqualified under section 8 subsection 2. For any other offence for which you are convicted for more than 2 years, then you will be disqualified under provisions of section 8 and subsection 3. So this is the legal mandate for disqualification of MPs from Representation of People's Act. And there are also certain constitutional provisions for disqualification, like whether fees of like unsound mind or undischarged solvent, or he loses his citizenship. So all those constitutional provisions of disqualification is also there. So I think you need to like focus on that also. I think that is needed. Then other grounds of disqualification. There are also other grounds which are mentioned in the Representation of People's Act. I think those also you need to like focus on. And what are the remedies if the person disqualified has to approach Election Commission, High Court and the Supreme Court, or the legislative pardon? I think this legislative pardon is something which is the prerogative of the state assembly and the Rajya Sabha, Lok Sabha. I think that is not like usually mentioned or talked about, but there is also a provision of legislative pardon to reinstate the disqualification of the MP or the MLA. I think that area many might not be knowing, but so UPSC might like ask. Hello. Moving on. Okay, now comes the major current affair for polity and governance for this year. That is elections. So as I said already, you need to be knowing about Article 324, the powers of the Election Commission. So 324 entire article you have to like read, and then Article 325 it tells that there will be a common electoral roll for elections to parliamentary constituency and the state assembly constituency, and then nobody can be discriminated for their inclusion based on the grounds of race, religion, caste, sex, or any of them. So this is there in like Article 325. This might be asked because like this election, usually every election there will be this question of like names being left out in the voters list. So this might also be asked. And then next is your universal adult suffrage. The Article 326 gives you the constitutional right to vote. And one thing is like I think in 2017, once UPSC has asked whether right to vote is a statutory right, constitutional right, fundamental right, something it gave like 4 options, and it's actually a constitutional right. It's not a fundamental right because not every citizen can exercise right to vote. Citizens who are over and above 18 years of age can only exercise the right to vote. So it's not a fundamental right, rather it's a constitutional right. It's given by the Constitution. And the next thing is like delimitation of constituencies. So delimitation, I think we'll discuss further. Try to know that. Yeah. The next thing is like electoral funding, which you need to know because recently the Election Commission of India has suspended the recognition given to National People's Party (NPP) because it had failed to lodge the electoral expenses of the 2014 Lok Sabha elections. So and then this legal thing Your electoral funding is broadly covered under Representation of People Act 1951, Conduct of Election Rules 1961, Companies Act and Income Tax Act. So you have to like have some idea about like all this. So your next thing is electoral funding. So as I said, the Representation of People's Act 29B, 29C, and your IT Act 13A, it has something related to electoral funding. I think your 29B, it tells that you have to, the political parties need to disclose the accounts or the information of donations if they are more than like 20,000 rupees. So actually, like 29B tells that they are entitled to like voluntary contributions. So 29B tells that, 29C tells that if the party is receiving like funds more than 20,000 rupees, then they are like mandated to like disclose that the election commission. So that is 29C. And your 13A of IT Act tells that if suppose the political party is like filing IT accounts every year, then the political party is exempted from paying income tax. So that's what it is. So I think there are other provisions also with respect to electoral funding. Just like go through them. And then the next is the Companies Act and conduct of election rules, and these also have certain provisions regarding electoral funding. So just go through that also. And then Foreign Contribution Regulation Act of 2010. So based on this, even your foreign companies can also like do political funding. So this was there. And then with respect to Companies Act, the provision of your corporates donating, the condition that they must have a profit for like the past 3 years. I think those condition was removed during this electoral when this electoral bond scheme was launched. So Companies Act also has some provisions related to electoral funding. So and then yeah, this is like one of the reasons why I had picked this. Electoral bond verdict was declared unconstitutional on February 15 of 2024. I'll not forget the date because that was the day when I had my civil service interview, and I was in the morning session. And the first question that my chairperson had asked was from this, and I didn't even know that the verdict had come. But my chairperson was like very particular to know about my opinion on electoral bond. So I'll never forget the day on which the electoral bond was declared unconstitutional. So you just need to know about who issued that, its validity, who all can like receive, and then the verdict details, and then this Article 19(1)(a). This is like very important because Supreme Court had referred to this article in its verdict. So knowing Article 19(1)(a) and the limitations on the fundamental rights or the exemptions. So knowing all this is like very important. And then recently there was a revision on the electoral expenditure as well. It was revised from 70 lakhs to 95 lakhs for a Lok Sabha constituency, and from 28 lakhs to 40 lakhs for a state legislative assembly. And this is like only for individuals and not for political parties. So this is like something very important to note. This is actually the provision that is like making people to spend a lot for the in the election process. So this difference must be known. Yeah, next thing is like recognition of political parties. Why I've taken this is like recently for Aam Aadmi Party, it had received the status of national party, and your CPI, Communist Party of India, it had lost its national party status, and also Trinamool Congress had also lost. I think right now you have six: Aam Aadmi Party, Bahjan Samaj Party, your BJP, Indian National Congress, Communist Party, Marxist, and the National People's Party. One, two, three, four, five, six. So you have like six parties which have like national party status. So that is like very important. And then they are given that status based on election symbols order 1968. And then you need to know the criteria that is like given for the national and the state party status. And you need to know some of the names. Maybe names they might UPSC might not ask, but the criteria is something which UPSC might test on. And then you need to know the difference between a registered party, registered and recognized parties, and registered and unrecognized parties. Then you know the difference. And then next is like allotment of symbols to political parties and the role of election commission here, because there was this issue in Maharashtra where you had two factions in the Shiva Sena and the two factions in National Congress Party under Sharad Pawar also. So, and Supreme Court, the Election Commission had granted the symbols to Shinde faction, the Shiva Sena symbol to the Shinde faction, and the Ajit Pawar faction had taken the National Congress Party's symbol. So, allotment of symbols to political parties and role of Election Commission there, and legal all the rules that govern the action of ECI. I think that can be asked. So we need to like focus on that also. And then de-recognizing and deregistering a party. I think there's always a difference between de-recognizing and deregistering, which is not like understood by many. You can be registered and be unrecognized, because for recognition you have a set of criteria that you need to receive like 6% votes or 8% votes or these many like seats in Lok Sabha or in state legislative assembly for the political party to be recognized by election commission. But to be registered, just mere existence and following all the legal provisions and the rules set by election commission is more than enough for you to be registered. So there can be a lot of parties who are registered, but they may not be recognized. So the election commission can de-recognize a party, but it cannot de-register a party. It has the power to de-recognize, but it does not have the power to de-register. So your de-recognition can happen if you're not participating in elections. If the political party is just registered but is not participating in elections, and it has no audited accounts and it has no vote share that is needed for it to be recognized. And the party can be re-registered if there is a if the registration is done by fraud, or if the political party is declared illegal by the government, or the political party has amended its internal constitution or the rule book, which makes it to no longer abide by the Constitution of India. So, under all these three circumstances, you can deregister a party, but this will come through your courts and the government, but this will not happen through election commission. So, I think that difference we need to know. Like going forward, corrupt practices in elections. I think this is like governed under Section 123 of Representation of People's Act of 1951, and there is an exhaustive list on what constitutes a corrupt practice. So you need to have some idea about all the corrupt practices which are mentioned in Section 123. And then there is a question on As also a mention about false affidavit filed by the candidate, and it is covered, and it's not covered under corrupt practice of section 123, but it is dealt separately, section 125 of Representation of People Act. And for this, the conviction which you have under, so because when we discussed section 3, section 8, subsection 3 of Representation of People's Act 1951, it talks about disqualification of MPs or MLAs for convictions other than that is discussed under section 8 subsection 1 and section 8 subsection 2. If you're convicted under any other provisions under these two, other than subsection 1 and 2 mentioned under section 8, you'll be disqualified under section subsection 3. But if you are convicted under filing false affidavit, you will not face any disqualification under section 8 of Representation of People's Act of 1951. So this is something, this is a loophole actually. It's not a loophole, but this is something that needs to be like corrected. And there is no role of election commission to disqualify a member for filing false affidavit. So it will come through the courts after an election petition is filed before the High Court, and it can go for appeal to the Supreme Court. I think those conditions, this is like something which differentiates between false affidavit and corrupt practices. And just need to go through about the list of Supreme Court judgments, like the Association of Democratic Reforms or the PUCL verdicts, that has talked something about corrupt practices, filing affidavits, disclosing criminal antecedents, disclosing the assets of your close relatives of the candidates. I think all those you need to just have some idea. Next thing is this postal ballot and voting from home. So you under this you will have a lot of terms which we often tend to overlook. I think the first thing is a special voter. Who is a special voter and what constitutes special voting? That is something which is said in Representation of People's Act of 1950 and not 1951. So this is very important. And who is a special voter? Your president, vice president, union minister, and governor. Only these four are special voter under Representation of People Act of 1950. This is very important, very, very important. And you have voters on special duty. Voters on special duty is nothing but any government servant who is on election duty and who is not able to cast his vote in his or her native constituency, so they can vote through postal ballots. And then electors under preventive detention, they have the right to vote and they can vote through postal ballot, but convicts cannot vote. Only people under preventive detention can vote. And then this is a new term, Divyanjans. Like recently, like this age limit was revised. Previously, people over 80 years can like vote through this postal ballot, but now that was like increased to 85 years, and then persons with disabilities can also vote through postal ballot. So you'll have one presiding officer and two other people who are like accompanied to the home, and then you have to vote in your home, and maximum up to 2 times they can visit on the day of polling. They'll visit for the first time. If the person is not concerned person is not in the home, again they might give you a visit in the evening, and if you still you're not there, then your right to vote ceases to exist, or not right to vote, you having the opportunity to vote, it ceases to exist. And then other people who are there for the essential services on the whole day, for instance media people, people who work on metros, people working in railways, healthcare. I think all those people they tend to get chance to vote through postal ballots. And then you need to know who's a service voter. Generally, a service voter is person who is belonging to the armed forces, army, navy, air force, or the central armed police forces, and their spouses, or like diplomats who work abroad, who are like posted abroad, and their spouses. So everybody, all of these contribute to the term service voter. So here you need to know about who's a special voter, who are voters on special duty, this Divyangjans, essential services, and service voter. So if you are like aware of all these terms, is like more than enough here. Moving next. Yeah, VVPAT. VVPAT is like voter verified paper audit trial, and this is like frequently in news because of the demand from the political parties to in the like Supreme Court to direct the Election Commission to verify 100% VVPAT sheets or the papers with the EVM like results. So that case was something that usually happens just before the elections. So that happened this year also. So you might expect a question on that. So you need to know when was VVPAT first introduced. It was like used in 2013 during the assembly election in Nagaland. And then what are the like details? It displays candidate serial number, name, and the party symbol. And it was like introduced after like amendment to conduct of election rules 1961 and not representation of people's act. So I think these issues you need to, these areas you need to know. And then one small thing is how election commission uses this VVPAT and how it is verified. I think that is also something that you need to know. And the Supreme Court verdict regarding that and the arguments of the election commission. I think arguments of election commission is something that you can use it for mains, but for prelims, like these aspects are enough. Yeah, the next thing is like delimitation commission. So your delimitation commission as a constitutional provision, it's a statutory body, but its existence is the power for its existence comes from the constitution, article 82 and 170. So your delimitation commission, it generally consists of a retired Supreme Court judge, a chief election commissioner, and the state election commissioners. So like the purpose of delimitation commission is to draw boundaries of constituencies and determine the number of, not determine actually, is to like draw boundaries of the constituencies, and it is like usually appointed by the president, and the number of seats that it is going to delimit is like frozen till 2026 as per the 84th amendment. It is now based on 1971 census, but for the first time it was frozen in the 42nd amendment. But for the 42nd amendment it was like frozen till 2000. But the 84th amendment had extended that like freezing status till 2026. So the first census that happens after 2026 will be the foundation for delimiting the constituencies. So like this was there in news. Your delimitation commission was there in news, and but the boundaries are redrawn to adjust for the see the delimitation. How it is delimited is the ratio between the number of seats and the population that every state represents will be uniform across the states. So that is there, and even in between states, the population that every member represents is also something that your delimitation will try to have a balance. So between states and even between constituencies, it will try to maintain a balance. So that's how your delimitation is done. So based on your 2001 census, your boundaries are readjusted for the population without differing or like changing the number of seats. And also reservation for SC and ST candidates is also governed based on the 2001 census and not 1971. This is something very important. So yeah, it's appointed by the president. Your composition is you'll have a retired Supreme Court judge, chief election commissioner, and the state election commissioners. And powers. The report of the delimitation commission is final. It is held. It is laid before the parliament and the state legislative assemblies. It cannot be challenged in the court of law. The decision of the delimitation commission is final. So that gives the delimitation commission some enormous powers. So that's something you need to know about. Moving forward, motions. Okay, I think this motions is something like very important because we had a lot of privilege motions which was brought by the MPs, but it was not admitted, and the role of speaker in admitting motions because Lok Sabha speaker, the 617 Lok Sabha speaker had not actually admitted a lot of motions that was like proposed by the members. So for those reasons, I think motions can be asked. So like you have to know about the types of motions. Closures you have like simple closures, kangaroo closures, compartment closures, guillotine closures. I think you need to know all those like types of closures. And then privilege motion. Whenever the house feels that the privilege of the house is under stake, a privilege motion can be moved and there can be a discussion on that. And then you have adjournment motion. Your adjournment motion is to bring to the notice of the parliament or the house a serious issue which has not been like discussed much, but which has a very good amount of public interest. So adjournment motion, if admitted, it will have some 2 hours and 30 minutes discussion. So like that's very important. And then censure no confidence motion is against the entire council of ministers. When there is a feel that the house is going to lose the trust of the government, then a no confidence motion can be admitted, and you need at least some number of like MPs to in support. I think 50 MPs, if I'm not wrong, that is it. And then censor motion, it is not against the entire council of ministers, but it can be against any one particular minister. So if at all your censor motion is passed, that doesn't amount to loss of trust of the house on the government, and the government need not resign. But in case if a no confidence motion is passed, that will amount to loss of faith and trust by the house on the government, and the government has to resign. So that's the difference between no confidence motion and censor motion. That's it, something important. And then resolution versus motion, you need to know the difference. All resolutions are motions, but all motions are not resolutions. That's a simple thing that I can like, give you, and you have to like work on like the types of resolutions and the types of motions. Next thing is like vice president election. I think UPSC is now getting into the habit of like asking questions from current affairs which are like 2 years old. So going by that trend, I think in 2022 we had the election, vice president election in 2022, and so there's a chance that you might be asked. So that's the reason I picked this topic. And we need to know what is Article 63. It talks about the office of vice president and the roles, responsibilities, and the powers that he has. In the electoral college of a vice president is the Lok Sabha and Rajya Sabha in entire, be it either elected or nominated members. And here you need to know the differences between the electoral college of the president as well as for the vice president. For the president, the electoral college is the elected members of both houses of Lok Sabha as well as Rajya Sabha, and also the state legislative assemblies. But for a vice president, your state legislative assemblies, the members of state legislative assemblies, they have no role in the election to vice president. But your nominated members of both Lok Sabha as well as the Rajya Sabha, they have role in election to the office of vice president. So that's the difference you need to know between president as well as the vice president election and the electoral college. You need to know the constitutional provisions and the powers. So it's usually the Election Commission of India. They conduct the election via the Secretary General of either House of the Parliament. See, I think in one election, your Secretary General of Lok Sabha will conduct, and in the other, your Secretary General of Rajya Sabha will conduct. So they'll take turns for every election. And the powers, like your vice president is the ex officio chairman of Rajya Sabha, and he conducts and supersedes this, like supervises the sitting of the Rajya Sabha, and he or she ensures that the House is run as per the parliamentary conventions. Term and removal. Your vice president is generally elected for 5 years, and he or she can be removed by a special effect, not special, a special majority, but an effective majority, which is a kind of a special majority. So basically, your vacant seats are like excluded, and in that you need like for more than 50%. So that's effective majority in Rajya Sabha, and it must be passed by Lok Sabha by a simple majority. So if that is passed, your vice president is like removed. I think those areas you need to like know. And then if at all, I think as far as like my knowledge goes, the vice president of India and vice president of US hasn't been compared till now in questions, but you might be asked on those lines as well, because one similarity is that your vice president acts, the vice president of US acts as the chairperson of the Senate, just like how the vice president of India acts as the chairperson of Rajya Sabha. So there are some similarities and dissimilarities as well, I think. So that is something you need to like work on. Okay, next is the office of governor. The office of governor, I think it is on a lighter note. It is like becoming more popular than the office of president, because like for good reason or bad reason, that's something like beyond the discussion of, beyond the scope of discussion, but it's something that is repeatedly in news because you have the tussle between your Tamil Nadu governor and elected government. And then last year, until last year, we had last year or last before year, we had the issue between the West Bengal governor and the elected government there. And then even now we have issue between governor and governor of Kerala and the elected government there. So for all like good or bad reason, you have the office of governor in news. So that's why I've picked up this. So now you need to know about like what about the constitutional provisions. Article 153, it provides for the office of governor, and the executive power of the state will be vested on the governor. He acts as the head of the government at the state. sorry, head of the state at the state level, and then your governor has to act in accordance with the advice of the Council of Ministers, aid and advice of the Council of Ministers, and except where it needs his discretion. And then you need to know about constitutional discretion and the situational discretion. To discuss constitutional discretion is something like reserving the bill for presidential assent. That is a constitutional discretion, and recommending for president rule. That is his constitutional discretion. And then one more constitutional discretion is when this governor acts as uh, the administrator for the adjoining union territory. I think one example could be there was this governor of Telangana who was also acting as lieutenant governor of Puducherry. So when the governor is acting as lieutenant governor of Puducherry, he or she is not bound to act on the aid and advice of the Council of Ministers of that Telangana state. So all these three are like constitutional discretions. Situational discretions is when no party after an election, when no party is like finding as having the absolute majority, so it's upon the discretion of the governor to call upon the party to prove their majority, and then to dismiss the council of ministers when they have failed to like prove their majority in the floor of the house. So like these two are like some of the situational discretions. I think you need to know all this. So the difference between constitutional discretion and situational discretion is something needed. And his or her role as vice chancellor, this is something like very bothering in the Kerala government as well as in the Tamil Nadu government. So there's a tussle going on that. I think this you might expect this in mains, but not in prelims. And then yeah, this recommendations of Sarkaria and Punchi Commission. I think there was one in 1 year. There was a question that directly was asked regarding the office of governor, and one recommendation. I think one recommendation was given, and they had asked which committee had recommended for reforms on office of governor, and the option was Punchi Commission or Sarkaria Commission. I'm not very sure, but it was a question that was like directly asked from this, so you need to know. Yeah, now comes the favorite part of UPSC. Every year, UPSC asks some question which is directly or indirectly linked to preamble. Either it could be like in which constitutional amendment was the term socialism and secularism was added. That might be a question, or there might be a question on what does justice mean or liberty mean. I think in 2019 they had asked what is the meaning of liberty, and like they were like some four options, and I think two options that I remember can be one was absence of restraint, and another was having conditions that that enable one to develop fully. So I think they might give you the terms that are there in the preamble, and they might ask you what do they actually mean, and justice, why it is like social, economic, political, and why it is not political, economic, and social. Why it's not the other way around. Why the terms are placed in such a way, that is also important. And then equality of status and opportunity. I think your equality of opportunity. I think this is where your the question, the provision for reservation actually flows from, because your reservation gives you adequate equality of opportunity, and then fraternity, assuring the dignity of individual, unity and integrity of the nation. I think this was also added by some amendment. Yeah, it's given here, 42nd amendment. That's very important. And then this adoption day, that's also important. So other areas is whether preamble is a part of constitution or not. I think you have a lot of cases like either the Shankari Prasad case or the Golaknath case or the Kesavananda Bharati case. You had a lot of cases that discussed whether your preamble is a part of the constitution or not. But the Kesavananda Bharati case, I think that has finalized that discussion. Your preamble is a part of constitution, and then you have significance of a preamble. It sets, it actually broadly tells the goals and ideals of the constitution. It, by reading the preamble, you can actually know what the constitution is speaking, and it talks about the source of power. Since it's talking about we the people of India, it's telling that the constitution actually derives its authority from the people. So that's the significance of preamble. And then I think preamble has been amended just once, 42nd Amendment, to include secularism, socialism, unity, and integrity. So those terms were added. And then this was asked in 2020 or 2021. I'm not very sure. One of the option was your preamble has provisions and it does not have any legal effect that is independent of the constitution. So like that is very important. So expect a question on preamble, either with the terms or with the amendment or the significance of preamble, or like whatsoever. There will every year there is definitely a question on preamble. So you need to like work on that. Next thing is India, that is Union of States. I think this have picked because there was like 2 years before there was a discussion on whether India is whether this question of central government or union government was like going on, and you had a lot of references to Article 1, which said India, that is Bharat, that is Union of States, is a union of states. So I think Article 1 to 4 is something that you need to know, because Article 2 talks about admission and formation of new states, and Article 3 talks about drawing the boundaries, renaming states, and Article 4 talks about any changes must amend Schedule 1 and Schedule 4 of the Indian Constitution. I think Article 1 to 4 you need to know. And why I've picked this is like you had this formation of Jammu Kashmir, and the capital for Andhra Pradesh is now like recently changed. So citing all this, there's like good amount of chance that you can expect a question on Article 1 to 4. I think apart from this, see all the constitutional articles you need to be clear, because some way or the other they might be in news. Say for instance, your Article 5 to 12. Actually, these weren't in news, but the question of citizenship, because since you had your Citizenship Amendment Act was enforced this year in 2024, so you might not have a question on Citizenship Amendment Act, but you can expect a question on the constitutional provisions on citizenship under Article 5 to 12. So it's better you be very thorough with all the constitutional articles, Article 1 till 25, sorry 35. I think all the constitutional articles you should be like very clear and thorough with the wordings and limitations on fundamental rights, everything. Going forward, right to freedom of religion. This was in news because like you had the discussion on freedom of religion ever since this Ram Janmabhoomi case and the Gyanvapi mask. So Article 25 to 28. Need to know what is this freedom to practice, profess religion. That is like very important. And then right to administer properties, and then right to not pay taxes to promote any particular religion, and then minority rights. I think all those provisions are there in the textbook. any polity textbook, I think you need to be very thorough with Article 25, 26, 27, and 28. So like that is very important. And then you need to know the difference between concept of Indian secularism and Western secularism. I think this was asked in 2019 mains actually. The question was like this: what do you think France can learn from Indian secularism? So that was a question. And this year might be, you might expect a question on that, but with options. Maybe UPSC can give you options and they might ask you to choose the right difference between the Indian secularism and Western secularism. So that is something which is like very important and we need to like have some idea about. Going forward, next is like local governance. See, local governance is again something very static. Some way or the other, it will be in news. But one good reason to expect a question this year is because the Ladakh was demanding Schedule 6 status. So you need to, so once Schedule 6 comes in, you need to know what is Schedule 5, Schedule 6, and what is the difference between Tribal Advisory Council and Autonomous Council. Your Tribal Advisory Council comes under section Schedule 6 and 5, and your Autonomous Councils come under Schedule 6. And you need to know what are the differences between Schedule 5 and Schedule 6, and the powers that are granted under Schedule 5 and 6, and what are the differences, how members are nominated, role of governor here, and the role of president here, all those matters, and then the powers that are granted under Schedule 5 and Schedule 6. You need to know about that also. I think this once this Tribal Advisory Council was asked in 2019 prelims. Tribal Advisory Council comes under which constitutional provision, and the question was like pretty straightforward. And then the 73rd and 74th Amendment Act, you need to know, and you need to know about the compulsory and the voluntary provisions for the state governments to adopt. See, like compulsory provision is reservation for women is compulsory, reservation for IC and STs is compulsory, setting up local governments 3 tiers is compulsory, but voluntary provision is reservation for backward classes was voluntary. So there are certain like compulsory and voluntary provisions for the states. I think you need to know what are those. Going next, this is the Rajya Sabha elections. There was this Rajya Sabha election was in news because like you had this question or the discussion on cross voting that was there. I so think that is something that you need to read. So Rajya Sabha elections, whether how it is happening, what is proportional representation, what is single transferable vote, and how the voting happens, whether it happens through a open ballot or a secret ballot, and why there is no nota. There's recently a Supreme Court verdict telling that nota is not applicable to the Rajya Sabha elections, and similarly there cannot be any whip direction. And even if in case like you are voting apart from the directions that are given by your political party, it will not amount to defection. So there is no whip granted. There is no whip direction here. Like that's very important. And the next is like fundamental rights. Like as I said earlier, all the fundamental rights from like 14 to 35, you need to be very very thorough. Exceptions on fundamental rights, you need to be very thorough. For instance, like UPSC asks questions like when was what was first constitutional amendment. I think in 2019 there was a question on fundamental right amendment to Article 15 and 16. There was not directly under whose prime ministership was the first constitutional amendment bought, or reservation was bought, something, some question like that. So directly or indirectly, you might expect amendment to like Article 15, 16. You can also expect question on reservation for economically weaker section and the constitutional amendment that brought that. And then we need to know about right to information, right to freedom of speech and expression, because Article 19(1)(a) was referred by the Supreme Court in the electoral bond verdict also, and exceptions to fundamental rights. 19 clause 2, clause 3, clause 4, clause 5. I think you need to know all that. Sorry, 19(1)(a), B, C, D, E, F. So all the exceptions you need to know, and Article 20, 21, because every year Article 21 is getting like reinvented. The scope of Article 21 is like getting expanded. So that you need to know. Whether right to marry, I think this was asked in some 2 years before. Right to marry is a fundamental right under which of the following articles? There was like Article 21, so that was asked. And then protection from arrests, preventive detention, punitive detention, that comes under Article 22. And then right against exploitation, forced labor, and child labor, that comes under Article like 23, 24. And then right to freedom of religion, which you've like discussed already, 25 to 28. Culture and educational rights, Article 29, 30. So like all that you need to know. And then 32 is like jurisdiction of the Supreme Court. What is like mandamus, quo warranto, certiorari, prohibition, habeas corpus. All those terms you need to know, because like UPSC asks questions from Article 32 every year. The other alternate year, there is a question on jurisdiction of Supreme Court. And then Article 33, 34, 35 is something that UPSC hasn't touched for prelims, but there's quite a good amount of chance that you might be asked. So I think, yeah, you need to focus on articles 1 to 35 with special emphasis on like these four articles. I think that's like very important. Next is, yeah, fundamental duties and directive principles. Yeah, every year fundamental rights you can expect one question. Directive principles and fundamental duties put together you can expect one question. So if at all there's a question from directive principles, there might not be a question on fundamental duties, but if there's a question on fundamental duties, will not expect question on directive principles. And sometimes there are years where you have been asked questions from both are asked. So your directive principles, they are fundamental to the governance of the country. This was a statement in 2016 or 2017. I'm not very sure. But directive principles are fundamental to the governance of the country. It sets broader goals and objectives for the executive, not the executive, for the state to act on. So that is the directive principle. So you need to like know from Article 38 till 50. You need to know what are the like directive principles and which are like Gandhian principles, which are liberal principles, which are like socialist and which are like international. I think this is segregation for the directive principles, and those differences you need to know. And amendments to directive principles you need to know. There are certain like directive principles which were like introduced by the 42nd Amendment, and there are certain directive principles which were introduced after the 44th Amendment. So that you need to know. And fundamental duties is something that was incorporated. It was not a part of the original constitution. The fundamental duties have come from the Russian constitution, I guess. So it was like incorporated after the 42nd Amendment Act. So that is like something very important. It was based on Swaran Singh committee's recommendation. Then initially, like we had some 10 fundamental duties, and it was amended once in like 2002, the 86 amendment, which just added one more fundamental duty. So that all that you need to know, and you need to be like very clear about all the 11 fundamental duties, their wordings. All those are like important. And going forward, the constitutional bench. Yeah, why this? Why I picked this is because an electoral bond verdict was given by a constitutional bench of like 5 Supreme Court judges. So Article 143, Clause 5 talks about should have at least 5 judges, and there are conditions like for when a constitutional bench can be created. Can be during the president when the president exercises his not discretion, his advisory jurisdiction. Is 143 which we discussed. So that for that, or when there is a reasonable like constitutional question involved, or whenever there is a dispute between the single judge bench and the divisional bench. If at all there is a issue there and there needs to be any significant constitutional interpretation that needs to be made, I think then your constitutional bench kicks in. You need to be like clear with all that. The last topic is National Commission for like backward classes, scheduled castes, and scheduled tribes. This is like frequently in news because I think since 2018 or 19, your National Commission for Backward Classes was given constitutional status from the statutory status, and then after that, the act was also the constitution was also amended to give the National Commission for Backward Classes and the state governments to notify the backward class list. So you need to know about the 102nd Amendment, the appointment, how the members are appointed, the composition of the members, the composition of the commission, the constitutional status, and the role in protecting the interest of the group, and the limitations. I think this is something, limitations is something that will like focus for mains aspect. I think as of now, you need to know like the amendments. When all these were given constitutional status, all those amendments you need to know. I think yeah, that is there. Yeah, that's it. So we have finished like polity and governance, and this is just the list that I've made is just an indication. It's not like exhaustive. We might have also like missed on a few topics, but like directly or indirectly, if you get at least like 5 to 10 questions from areas that you have discussed in polity, that's like more than enough. So I think if you just focus on these areas, there's high probable chance that you'll have a lot of questions which you know for prelims, and there's high chance that you might crack prelims this year. So we are done with polity and governance. So similarly, we'll do for economy, science and tech, environment. We'll work on those areas and history as well. So with that, like we'll wrap up. So that's it for this session. Thank you.